For the longest time, just trying to figure out your paycheck in India meant navigating a total maze of laws, some of them dating all the way back to the 1930s. Now, as you can imagine, this created a lot of confusion for employers and a ton of uncertainty for employees. But then, in 2019, all of that changed. So today, let's break down the landmark reform that finally untangled this web, the Code on Wages.
So what was the real problem here? Well, at its very core, the system was fragmented across 4 different and very old laws. This just created confusion, loopholes, and inconsistencies for everyone, for employers trying their best to comply, and for employees who were just trying to understand their basic rights. The goal of this new code was to change all of them. I mean, just imagine trying to navigate 4 different rule books simply to understand your own paycheck. That was the reality. You had one law for how you get paid, a completely different one for the minimum you could be paid, a third for bonuses, and a fourth to ensure equal pay. It was a complete patchwork that was long overdue for an upgrade. And just look at the dates on these laws for a second. 1936, 1948. They were from a completely different era of India's economy. So consolidating these 4 acts, the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act was the absolute first and most critical step in this entire reform.
So, the solution is the Code on Wages, 2019. It's designed to be a single, streamlined rulebook that brings simplicity, clarity, and, most importantly, universal protection to the entire workforce. So let's see how it does that, starting with a very basic question. Who is actually covered?
The code starts by defining who an employee is, and you'll notice it's intentionally broad. It covers almost everyone, from unskilled manual labor all the way up to senior managers and administrative staff. And this is a really big deal, because it means that basic protections like getting paid on time now apply to nearly the entire formal workforce. Now here's where the law makes an interesting distinction. It separates an employee from a worker. While employee is that big, broad term that covers almost everybody, worker is more specific. It often excludes senior managers. Now why does this distinction matter? Well, it can be absolutely critical in situations like industrial disputes or collective bargaining, where that legal definition of worker is key. Okay, now let's get to what is arguably the most significant financial change in the entire code. It actually redefines the very meaning of wages, and this has a direct impact on your paycheck and your Social Security.
So, for the very first time, we have a single, uniform definition. Legally, your wages are now consistently defined as these 3 core components: your basic pay, your dearness allowance, which is there to help with inflation, and any retaining allowance. This trio forms the new foundation of your salary.
This table lays it out pretty clearly. On the left, you've got what's always in your core wages. And on the right, you have all those other allowances, like HRA and travel, that are typically excluded from that core definition. But, and this is a really important but, there's a catch.
And that entire catch revolves around this one number, 50%. This is the magic number that's designed to prevent companies from gaming the system.
Here's how it works. To stop companies from artificially lowering Social Security contributions by inflating all those allowances, this rule was created. If all those excluded allowances add up to more than half of your total pay, then the excess amount, the part that goes over 50%, gets added right back into your core wages. This makes sure your Provident Fund is calculated on a fair, substantial portion of your real income, not just a minimized basic pay. All right, now that we understand the money part, let's look at the new rules of the road. The code sets out very clear rights and responsibilities for both employees and employers that really change day-to-day operations.
This is one of the most powerful changes. You see, previously minimum wage protections only applied to certain specific jobs, which covered just a fraction of the workforce. But the new code makes the right to a minimum wage universal. It applies to everyone in every sector, whether you're in the organized or unorganized sector. This is a massive expansion of the social safety net. The code also gets very strict about when you have to be paid. For monthly salaries, it's before the 7th of the following month. And for anyone leaving a company, their final settlement of all dues has to be completed within just 2 working days. This provides some really crucial financial certainty during those career transitions.
Now, what if you're asked to work extra hours? Well, the law is now crystal clear on what you're owed. The key multiplier to remember is 2.
That's right. For any time you work beyond a normal day, your employer must pay you at a rate of at least double your normal wage. This ensures you're fairly compensated for your extra time and effort, and it protects that fundamental right to rest and have a decent work-life balance.
The code also gives employees a lot more power by extending the time they have to seek justice if something goes wrong.
Here's another key protection. The window you have to file a legal claim for things like unpaid wages has been extended to a uniform 3 years. The old system was a confusing mix of 6 months to 2 years. This gives employees much more time to gather their evidence and pursue their rights without being rushed by a short deadline.
The code also takes a very powerful stand on equality. Section 3 explicitly prohibits discrimination based on gender, both in wages and in recruitment for similar work. And, in a very progressive move, this protection is explicitly extended to include transgender employees, making it a truly landmark piece of legislation for workplace inclusion. So when you step back and look at all these changes together, a bigger picture starts to emerge. You see, the code isn't just about tweaking a few rules. It's about fundamentally changing the entire philosophy of labor law in India.
And one of the most interesting shifts is the move away from a purely punitive model. For many first-time offenses, instead of facing criminal proceedings, employers can now resolve the issue by paying half of the maximum fine. The goal is to encourage compliance and correction rather than just punishment, though of course repeat offenses are still treated very seriously.
And this quote really captures the spirit of the entire reform. The ultimate aim is to strengthen economic justice, encourage the formalization of the workforce, and ultimately enhance the dignity of labor for millions. That's the real goal here. Building a system that fosters justice and enhances the dignity of work for every single person. By simplifying 4 laws into one, by creating uniform definitions, and by expanding protections to all, the Code on Wages has set a completely new foundation. It is a fundamental shift, and it leaves us with a crucial question to think about. How will this new, modern framework truly redefine the relationship between employers and employees in India for the future?
In the life cycle of every nation's economy, there comes a moment of fundamental transformation, a shift that redefines the very contract between capital and labor. We stand at such a juncture today. For over 7 decades, the Indian employment landscape was governed by a fragmented mosaic of colonial and post-independence laws. That era has ended. With the comprehensive enforcement of the Code on Wages 2019, we have moved from a patchwork of complexity to a unified regime of accountability, equity, and modernization. This is not merely a legal update. It is the new operational constitution for every employer and employee in India. Welcome to this comprehensive masterclass on the Code on Wages 2019. This legislation represents the first of 4 labor codes envisioned by the Second National Commission on Labor to consolidate India's regulatory framework. As per the Gazette notification SO 5322-E issued by the Ministry of Labor and Employment, the central government has appointed the 21st day of November 2025 as the date on which the core provisions of this code have come into force. This historic enactment repeals and subsumes 4 legacy statutes: the Payment of Wages Act 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, and the Equal Remuneration Act 1976. By amalgamating these laws, the code creates a singular, powerful authority on wage regulation. Its scope is universal, extending to all establishments and employees across the nation, organized or unorganized. Today, we will navigate this framework with precision, dissecting the legal mandates, the critical timelines, and the strategic imperatives that now govern your organization. Let us begin by deconstructing the legal architecture of the code, starting with the most critical shift, the definitions. The code introduces a unified definition of wages under Section 2-Y. This is the bedrock of compliance. Wages now include basic pay, dearness allowance, and retaining allowance. However, the critical change lies in the proviso. The code specifies a list of exclusions, such as house rent allowance, HRA, conveyance, overtime, and statutory bonuses. The law mandates that if these excluded components exceed 50% of the total remuneration paid, the excess amount shall be deemed as wages. This is a vital calculation for payroll processing. It ensures that employers cannot artificially suppress the basic wage to lower Social Security contributions. Consequently, your calculations for Provident Fund, gratuity, and leave encashment must now align with this comprehensive definition, likely expanding the contribution base for many organizations. Moving to Chapter 2, we address the universalization of minimum wages. Under Section 5, the right to minimum wages is no longer restricted to specific scheduled employments. It is now a statutory right for every employee in every sector. The central government, under Section 9, will fix a floor wage based on minimum living standards. No state government can fix a minimum wage below this national floor. The appropriate government, whether central or state, fixes the minimum wage rates based on skill levels: unskilled, semi-skilled, skilled, and highly skilled, geographical area, and the arduousness of the work. These rates must be reviewed and revised at intervals not exceeding 5 years. Furthermore, under Section 14, if an employee works beyond the normal working hours, they are entitled to overtime wages. The code explicitly mandates that overtime must be paid at a rate not less than twice the normal rate of wages. This applies universally, protecting the worker's right to rest and fair compensation. We now transition to Chapter 3, regarding the payment of wages, which dictates the strict timelines you must adhere to. Section 17 standardizes these deadlines regardless of the wage ceiling. For employees engaged on a daily basis, wages must be paid at the end of the shift. For those on a weekly basis, on the last working day of the week. For fortnightly engagement, before the end of the second day after the fortnight. And for the vast majority of professionals engaged on a monthly basis, wages must be paid before the expiry of the 7th day of the succeeding month. There is a critical compliance checkpoint here regarding employee exits. Whether an employee is removed, dismissed, retrenched, or resigns, the employer must settle their wages within 2 working days of their last day. Note that this applies to all employees, from the shop floor to the executive suite, eradicating the previous wage ceiling distinctions. This is a significant tightening of the timeline compared to previous practices, requiring agile coordination between HR and finance departments. Regarding deductions, Section 18 remains stringent. Deductions are only permitted for authorized purposes, such as fines, absence from duty, or recovery of advances, and the total deductions in any wage period must not exceed 50% of the employee's wages. Let us examine Chapter 4 concerning the payment of bonus. The code retains the fundamental structure of the 1965 Act, but broadens its applicability. Every employee who has worked for at least 30 days in an accounting year is eligible for an annual bonus. The statutory minimum bonus remains at 8.33% of wages earned, or 100 rupees, whichever is higher, regardless of whether the employer has an allocable surplus. The maximum bonus is capped at 20%. However, Section 29 introduces strict disqualification criteria. An employee is disqualified from receiving a bonus if dismissed from service for fraud, riotous or violent behavior, theft, misappropriation, or, notably, conviction for sexual harassment. This explicit inclusion of sexual harassment as a ground for disqualification reinforces the zero-tolerance stance of modern governance. The bonus must be paid within 8 months from the close of the accounting year, with payments credited directly to the employee's bank account. The Code also fundamentally reforms the inspection regime under Chapter 7. We are moving away from the traditional Inspector Raj to a system of facilitation. Section 51 redesignates the enforcement officer as an inspector cum facilitator. Their role is dual: to inspect, yes, but primarily to supply information and advice to employers and workers regarding compliance. Inspections are now web-based and randomized. Furthermore, for offenses related to record-keeping or other non-monetary contraventions, the inspector cum facilitator is legally bound to provide you an opportunity to rectify the non-compliance before initiating prosecution. However, do not mistake this new approach for leniency. Section 50 mandates rigorous record-keeping. You must maintain a register containing details of persons employed, muster rolls, and wages. Crucially, you must issue wage slips to every employee, either physically or electronically, serving as formal proof of employment and compensation.
Finally, regarding offenses and penalties in Chapter 8, the Code decriminalizes many first-time offenses, but the financial stakes are high. Under Section 54, an employer paying less than the due amount faces a fine extending to 50,000 rupees. Repeat offenses within 5 years can lead to imprisonment of up to 3 months and fines up to 1 lakh rupees. However, under Section 56, first-time offenses not punishable by imprisonment can be compounded, settled by paying 50% of the maximum fine. The burden of proof, under Section 59, rests squarely on the employer to demonstrate that dues have been paid. Having dissected the technical provisions, we must now understand the deeper strategic implications of this legislation. The Code on Wages is not merely a checklist of rules, it is an instrument of social engineering and economic formalization. First, consider the mandate for gender equality. Section 3 represents a robust commitment to non-discrimination. It prohibits discrimination on the ground of gender, explicitly including transgender employees, in matters of wages and recruitment for the same work or work of a similar nature. This goes beyond the preamble of equality. It requires organizations to actively audit their pay structures and hiring practices to ensure they are devoid of gender bias. This is further institutionalized in Section 42, which mandates that 1/3 of the members of the state advisory boards, now active under the notification, must be women, ensuring the female perspective is integral to policymaking. Second, the Code promotes the ease of doing business through digitization and simplification. By replacing 4 separate laws, it reduces the multiplicity of registers and returns. The single license, single registration, single return framework allows organizations to focus on productivity rather than procedural bureaucracy. The shift to electronic wage slips and bank transfers acts as a digital trail, protecting the employer from baseless claims while empowering the employee with transparency. Third, we must recognize the shift in the limitation period. Under Section 45, the time limit for an employee to file a claim has been extended to 3 years. This is a profound change. Not only do liabilities remain open for 3 years, but under Section 45, the claims authority has the power to award compensation of up to 10 times the claim amount. This exponential risk means that liabilities remain open for a longer duration. For employers, this necessitates a far more robust document retention policy. You must preserve wage records, attendance logs, and compliance filings meticulously, as a claim can arise years after an incident. For the HR and legal professional, the core message is one of proactive governance. The code treats the employer as a responsible custodian of the employee's welfare. The definitions have been tightened to prevent evasion, and the penalties for repeat noncompliance are severe. The prudent organization will not wait for an inspection. It will initiate internal audits immediately, ensuring that the cost to company, CTC, structures align with the new wage definition, particularly the 50% exclusion cap. Ultimately, this code is designed to formalize the Indian economy. By guaranteeing minimum wages to the unorganized sector and ensuring social security coverage through the redefined wage structure, it aims to uplift the standard of living for millions. For the corporate sector, it levels the playing field, ensuring that compliant businesses are not undercut by those engaging in unfair labor practices. As we conclude this analysis, let us reflect on the essence of the Code on Wages 2019. We have traversed the journey from a fragmented past to a consolidated future. We have seen how this code universalizes the right to minimum wages, establishing a floor below which no worker in India shall fall. We have understood the critical importance of the unified definition of wages, ensuring that Social Security is a substantive reality, not just a nominal benefit. We have noted the strict discipline required in payment timelines, the 2-day window for full and final settlement being a prime example of the efficiency demanded by this law. We have also seen the progressive face of the legislation in its robust protection against gender discrimination and its modern approach to inspection through facilitation. For you, as leaders and compliance custodians, the path forward is clear. It requires a harmonization of your payroll systems, a review of your employment contracts, and a sensitization of your management teams. The Code on Wages is not just about avoiding penalties. It is about building an organization that is legally resilient, socially responsible, and ethically sound. The notification of November 21st, 2025 marks the beginning of this new era. By adhering to these standards, you contribute not only to the stability of your enterprise, but to the dignity of the nation's workforce. Let this code be the blueprint for a fair, transparent, and prosperous professional environment. Thank you for your attention to this critical subject.